Dr. Maznah Mohamad, she's now an associate professor at the Department of Malay Studies and Southeast Asian Studies at the National University of Singapore. I've always said that when countries do not appreciate their people, they lose their people. And Maznah was with us in USM, and we lost her to NUS, our lost. She was visiting professor of ASEAN International Studies at the University of Toronto. I always admire the fact that she can really be very direct sometimes in her writing, and very brave to say what she wants to say. She has questioned, she has looked at the Malay handloom weavers, for example, in Kelantan, feminism and the women's movement in Malaysia, and this is a book, An Unsung Revolution, together with Cecilia Ng and Ben Hui, where are you? Yeah, Tan Ben Hui. Muslim, non-Muslim marriage, political and cultural contestations in Southeast Asia, together with co-editing together with Gavin Jones and Chi Heng Lim, and looking at changing marriage patterns in Southeast Asia, economic and socio-cultural dimension. She has looked at the Melayu, the politics, poetics, and paradoxes of Malayness. I saw this being featured in one of the newspaper cuttings in Singapore, and I was like, oh, Brani. That's all I can say. Brani. Really, to write about the Melayu, you know. And also together with Syed Muhammad Khairuddin Aljuni, she wrote Family Ambiguity and Domestic Violence in Malaysia, Concept, Law and Strategy. So from argument on concepts which have been very critical in shaping the discourse in Islam and Islamic law, we will now move to Dr. Maznah, who will be talking on the social costs of Islamic divorce in Malaysia. So, Maznah.
Thank you, Rashida. Can you hear me?
Yes.
Okay. Thank you. Yes, my topic is on divorce, but as you know, divorce is also related to marriage. I mean, there cannot be marriage without divorce and divorce without marriage kind of thing. Yeah, right. You know, the idea of marriage is to not be divorced. That's the whole idea. So the two go together, is two sides of the same coin kind of thing. However, the reason why I've chosen to concentrate on divorce is to actually expand on Ziba's argument about the basis of the Sharia law. Okay, what were the elements? And Ziba has very concisely and succinctly kind of given to us some of the core elements, which is the idea of men being guardians over others, not just women but also children. And obedience is a very core concept. Rebellion, nushuz, is of course there. And the other thing is beating. Now, these four elements are present in all our Sharia laws. So I'm going to zero in on the Malaysian Sharia law. Those are the four elements. And so when I started doing my research, I asked myself, how do I deal with this? Because as Rashida says, if you keep telling the people that, oh, the Sharia says that gender is unequal, you're not really going to go anywhere, because they say that is the essence of the Quran. And really, you have to do this very intellectual deconstruction to be able to see things that, well, Ziba has of course nicely put in. But I think if you go to the common people and say, look, you know, there could be some misinterpretation and so on and so forth, there'll be a lot of problem. So let me go. So what I'm going to do here is to look at the Sharia law in practice. And my argument is not to actually address the issue of equality or inequality, but I'm going to look at the contract itself, which says that man has got the so-called superior responsibility and therefore rights and therefore privileges over women, and in return for that, women are supposed to give their obedience and not be rebellious against men. Now, if you just go on the basis of that contract, okay, there's supposed to be an exchange idea here. Okay, has the contract been fulfilled? That's the question that we have to ask. Even on your own terms, never mind about us fighting about equality. Just on your own terms, have men been able to prove that they were the qiwamun, or the guardians over women? And have women actually been complying with the idea that they should be obedient to men. So those are the things. So in my paper, I think some of you have it, what I did was I looked at the case files, okay, of at least four Sharia courts in Johor Bahru, in Wilayah, in Jeli, in Kelantan, which is a small village, and in Penang. And so I looked through the divorce cases actually and see what went on there. So just as marriage is an unequal contract, of course we know all the things. I don't have to go through with you because you're all, I think, familiar with the idea of the unequal contract, right from the part where a woman cannot really be handed over to marriage without a wali and so on and so forth. Okay, in the divorce contract also, it's also unequal, right? Because men and women do not have the same rights to divorce. Now, my whole idea is to show actually, well, I hope eventually we'll be able to convince some people, not ulama, that there is a very high social cost to this type of contract. Okay, never mind that it's unequal, but on top of it all, if you look at it in practice, there's a lot of dysfunctionality in the contract. Never mind about being unequal, there's dysfunctionality. And because there's dysfunctionality, there's a huge social cost to society, not just to women, but to society. Okay, number one, I don't know whether you know it, but the divorce rates among Muslims in Malaysia and Southeast Asia has been one of the highest in the world. Right? In fact, Kelantan used to have the highest divorce rate in the world. This was in the 1950s. Of course, everything has gone down now. You know, the divorce rates has declined. In Malaysia today, overall, the divorce rates have come down, even among Muslims. However, among Muslims, out of all the ethnic groups, the divorce rates among Muslims remain the highest. Okay. So that's like if you want to kind of conceptualize social cost, okay, that's one thing. I'm not talking about rights. Of course, you can say people have the right to get married, to get divorced. But I think you're really talking about a group, when divorce happens among women here, it's not just women, but also children and families also suffer from all this. Okay, so that's the first social cost. Now, the other thing, I don't know whether you know it, but you know the highest proportion of single mothers in Malaysia is also Muslim. Yeah, highest single mothers. I think it has got a very tight connection to the divorce rates and also to the whole idea of this dysfunctional contract, okay, in marriage and divorce. So the social costs eventually will translate to, one, there will be a burden on state and society, right? Second, the whole idea of protectionism, as Ziba already said, it's like not equal, because protectionism then leads to what we call coercion and control, rather than responsibility, because the whole idea of guardianship should come with responsibility. But what we have in Malaysia is just protectionism that's being dysfunctional, translated into coercion and control, and violence, of course. Okay, that's kind of the extreme form. There are a lot of social disjunctures in judgments in the Sharia court, and I will just give you some examples, and of course then you can bring up. I have the paper, and you can look at the specific cases of this dysfunctionality. Now, for example, talaq. Everybody, you all know that only the man has a right, okay, to pronounce the talaq. Okay, fine, we've lived with it for a long time. We've not even able to change it. They can. It is an offense, of course, under the Sharia law, but they can just come to the court and just verify it, and then they get a very small, minimal fine over the offense, and everything's accepted. So, for example, there was one case that I looked at in Kelantan. So this young man actually pronounced a talaq in front of his wife. And oddly enough, this case showed that the couple went to the Sharia court and to actually get this whole talaq thing endorsed, okay, and formalized. So the judge asked the man to say, what did you actually say? And so he did say it's all in Kelantan, in dialect, something like saya jatuhkan talaq kepada the isteri, I pronounced talaq. And then the judge turned to the wife and said, is that true? And the wife said, yes, it is true. It seems very cordial, right? Two of them walking to the court, verifying, each other's action. And then of course the judge said, okay, that's since the wife has already said, endorsed that pronouncement, so basically registered the divorce. Now in this particular case, the wife was actually 5 months pregnant, okay? And so of course the iddah period would be extended until after she delivers. So you look at this case, here you have a situation of divorce done in a very cavalier, very nonchalant way, okay? And you have a wife who's pregnant. These are young couples. And what happens to them after that? So you can understand, I'm not saying that this is the reason why divorce rates are very high, but I think if you multiply this type of situation, you can understand why divorce rates among Muslims are very high today, because the judge, the court, is not prepared, for example, to regulate that sort of behavior. So that's a case of talaq. And you know that talaq can be pronounced even without the wife knowing that it has been pronounced. But this is a particular mazhab, right? You can, the husband can just say that I've already pronounced the talaq, and therefore, okay, the divorce is accepted. The SMS's divorces by talaq, there were at least 2 cases reported in the law journal. These are the reported ones, and both accepted, okay, the divorce by SMSs. There was one, this is talaq. Okay, another case is ta'liq. Ta'liq is a divorce by stipulation. Normally, we always think of stipulation when we are getting married, and we have that in our marriage certificate, which says what are the conditions under which a divorce becomes automatic, right? So issues like desertion and not paying nafkah, those are the standard things. However, in Malaysia, I'm not sure if it's every state, maybe Zainal you can clarify, but in Kelantan, even a ta'liq done orally can be accepted. So in one of the cases that I looked at, this was in Jili, the husband basically just said, if you decide to go and visit so and so and so, okay, the divorce will be activated. And true enough, the wife actually went out of the house to visit somebody, I don't know who this person was, and then the ta'liq was accepted, okay, by the judge. And then it was a very strange thing. Of course, it's more a complexity to it. I was reading through the case and I was thinking, actually, it could be the wife using it, because it had already happened before. Apparently, in the case files, apparently it was not the first time. So it's like they're playing a cat and mouse game, between the husband and the wife. So the wife would purposely kind of reenact the situation where the divorce would be activated. So that's one case. And fasaq, of course, is a very controversial condition, of course, for divorce among women. It is almost absolutely impossible, okay, for women to get divorced under this clause. Because you have to have your witnesses, you have to have all kinds of things, all kinds of proof. It's not enough that the man has deserted and not given nafkah to the children for 6 months. He has to be away, like one case, for more than 5 years, remarried other women, actually raped one of the daughters, yeah, and actually was unemployed and surviving on the wife's earnings. Finally, I think, after all that, the judge said, yeah, the woman's entitled to divorce. Yeah, I mean, I'm giving you actual examples. Okay, you might say, these are exceptions, but I mean, it could be the norm, Yeah. Finally, I just want to bring up the issue of muta'ah, because muta'ah is also another controversial clause. Controversial, when I say controversial, it's really the idea that although it's there, but women have found it really difficult to get compensation, okay, over divorce, largely because our courts, shari'a courts, they do not have any standard formula on how to award compensation, okay, for women in the divorce. At the end of the day, most of the judgments are due to the man's capacity to pay. So if it's a poor man, then the judge will just say, okay, you just pay $10 or $500 and so on and so forth. Now, I just give you an example. So a lot of women go to the court, and how do they claim for muta'ah? They will say, okay, I've been married a certain number of years, and if you calculate my worth as a wife, most of them calculated like about 100 to 200 ringgit. times the number of months, times the number of years, and so on and so forth. Okay, so that was what they applied for. And so in at least 3 cases, they only got like 20% of what they asked for. So for example, one case she asked for 23,000 ringgit and she was just awarded 5,000. Another case, 10,000, 2,400 ringgit. Another case, 43,000, she was given 6,500 ringgit. That's the kind of proportion, you see that. I don't know, I've yet to find out how did they come to this what I call amount. In another case, the judge actually used an old Quranic text in which there were these stipulations. It was an old, 12th century Arab land where the muta'ah was worth 108.8 grams of gold at that time. So there was one case recently, and the judge said, based on this text, this is the amount of muta'ah that this woman should get. So 100 grams of gold, whatever it is worth today. Okay, okay, that's the formula or whatever they use. It depends on the courts. Sorry. Yeah. So the social costs, here where the social costs come into the picture. In deciding on the muta'ah, I've not seen any, for example, arguments to look at children's welfare, for example. Okay, nothing of that is considered. The other is the damages. So, for example, if a woman can be just divorced in the middle of the street, okay, there's a lot of damage done there, right? So the cost, the award of the divorce is not at all contextualized as to how the divorce was obtained. Now, damages is a kind of thing that you can apply under English law. Where it is a kind of, when your body or your reputation is damaged, you can then apply for it under the law of tort, okay? And then the person who has afflicted you on the damage should be compensating you. Of course, nothing of that is done in the Sharia court. Women, even the defense lawyers, have not used that. But I will go on to a very interesting case later after this. I'll save the best for last, okay? So the social cost, again, when all these things happen, when children's welfare is not taken care of, when the amount of compensation is not commensurate, okay, with either the damage or the status of the man, okay, then you get what we have this situation of single women, having to fend off by themselves, of the children, and not only that, when the court pronounces, orders maintenance to be paid, no one goes after the man for the maintenance to be paid. So this is a persistent, very serious problem in Malaysia, to such an extent that in 2010, JAKIM actually announced the setting up of a fund to the tune of 15 million ringgit, okay, 15 million ringgit to, of course, help out the women who have not been getting their maintenance dues. This is what we mean by social costs, because why should we pay for the breach, okay, of these court orders among these men who are supposed to be protectors? They are supposed to be the qiwamah, the natural guardians. Even in that unequal contract, they did not actually stick to their bargain, their end of the bargain. And so we end up having to pay for it. Now, I'd like to sort of give this sort of argument, say to the ulama, to the religious people, and say, what do you have to say about this? Should we, be the one paying for your transgression of your own responsibility? Where's your manhood? I don't even care, I'll just use that. Where's your manhood? Where's your masculinity? Okay? What is this masculinity that you're talking about? When all of us are the ones, okay, are victimized by you actually not honoring your contract. So these are some of the issues. Okay, let me come to the issue of muta'ah, come to the issue of social cost, not in terms of that whole collective having to pay for the responsibility. Now, what about the reputation of the Sharia system itself? What about Islam itself? Aren't you afraid that your reputation is being tarnished because of all this? I'm going to come to this part about how our Sharia system treats the rich and the politically connected. The rich, famous, and politically connected. Yes, yes. Oh. Okay, let me begin by a much older case in 1998. It involves the then education minister. Take a guess. The then education minister in 1998. So his ex-wife wanted to apply for muta'ah. Okay? Wanted to apply for muta'ah. Now, he's famous, he's rich, he's powerful, and this ex-wife then said that in order for me to apply for muta'ah, I have to know the worth of this guy. Okay? So what she did was she applied to the Sharia court, the Sharia lower court, to allow for all of this guy's assets, okay, to be divulged, including assets that have been transferred overseas, including assets that have been transferred to his present wife, and so on and so forth. So it was rejected at the lower court. And then she appealed, and it came to the Court of Appeal, and they took, well, by the way, she was asking for 5 million ringgit, okay, from the a small sum, I'm sure now. So it was thrown out at the appeals level, and the notables that sat on the appeals board included Ahmad Ibrahim, the late Ahmad Ibrahim, Abdul Munir, and the professor, I think, in some Islamic university. And what was the reason for throwing out her application? Well, this is, I'm just going to quote, this is from the newspaper report, not from the Malaysian newspaper report, by the way. It was published in the Singapore Straits Times, but I don't think it made to the Malaysian newspaper. So they said, this is quote, muta'ah claims under Sharia law were different from actions for the division of property under the Matrimonial Causes Act in England, okay, where a court can consider the parties' present and future incomes, assets, and other means. We try to decipher what that means. Basically, they're saying, we're not like the English courts, okay, fine. So you cannot use the same principle of asking the ex-husband, okay, to declare the assets, whether his present, future, incomes, and so on and so forth. And therefore, on that basis, they threw out the application. And the ex-husband, who was a plaintiff, offered to pay the mother of his 4 children a sum of 36,000 ringgit. I was telling Zaina yesterday, you can't even buy a Protam Saga for that amount, 36,000 ringgit. This is the sort of thing, I think, this is a very serious, I think, it's tint on the reputation of the Sharia court and the people who sat on this appeals board. Because for one thing, it's very, very odd for a Sharia court to actually cite an English precedent. How odd, right? Here they are, trying to put themselves up as a contrast, okay, to Western law, and there they're using this as a precedent, okay, to throw out this woman's case. And I don't even know whether in Islam you're not supposed to do that, you know, ask for the husband's assets to be declared. Because how are you going to ask for compensation, right, if you don't know what it's worth? Yeah? Are you going to calculate what I'm worth on a daily basis times the number of years that I'm married to him? Of course, that's ridiculous, right? It's ridiculous. It has to be based on the worth of your spouse. Not, you know, whether I've served him, I've been no-shows, I've been rebellious, and so on and so forth. So this is a very powerful person, okay? And obviously the Sharia court has kind of succumbed, okay, to the powers that be. This was in 1998. I think maybe people were busy with the Reformasi, you know, they didn't bother with this case, okay? Now, contrast that to the present case. This is a very new case. This is the one that involves Taib Mahmud, the Sarawak Chief Minister's daughter-in-law, okay, Shahnaz Taib, who's the sister of Sheila Manjib. Actually, it's exactly the same case. Because what Shahnaz was doing was she was trying to ask the court to actually declare or release the information about the ex-husband's assets. Now, interestingly enough, the court didn't use the precedence of that case earlier. Okay? And in fact, the court allowed for the husband's asset to be declared. And so, you know, you get this a story about how the husband would spend 800,000 ringgit in 6 months, mind you, only on one credit card, right? And or maybe because she's smart enough, she actually kept all his accounts. She knew enough that he had 111 banking accounts, okay, all over the world. But the lawyers for the husband actually tried to do the same thing, tried to actually refrain the disclosure, okay, of his work. But the judge actually threw out the application, okay, by the defense lawyer. So that, okay, one final case among the rich and famous, of course, the Bung Mokhtar case, you all know about that, right? He took on the second wife, polygamy without court approval is an offense, and he didn't do that. Do you remember how much he was fined? No, very correct, yes, 1,000 ringgit, okay, fine, yes. So, except for the Shahanan's case, because we don't know what is the culmination of that case, because it's still ongoing. But the two cases really showed how, I dare to say, how bad, okay, our Sharia system at the moment, because they are not even, I would say, fulfilling their end of their bargain. They're not showing themselves to be credible as a justice institution. The qiwamah principle has been completely thrown out. We're not even asking for equality, okay? We're just asking for those kind of justice. So I think to kind of bring back what Ziba has said earlier, I think it's good to look, first, yes, theoretically, you know, there's already been something wrong theoretically about the whole concept of qiwamah, nushuz, and so on and so forth. However, it's become so embedded in our laws, whether it's in Malaysia or Indonesia or Iran, it's been so embedded that I think the only way for us to try to unravel all this is to look at the practice, law in practice, not about practicing law, but when we say law in practice, is to look at how that whole idea of law is kind of lived out, okay, in the real world. So my idea about the protectionism, it was the masculine protectionism. It's actually a term used by even Western feminists to even describe Western situation when they talk about the state. Because it's the whole idea of the state. If the state is supposed to be protectionist, it's supposed to also have responsibilities. Okay? And based on that, you're supposed to actually obey the state because you are getting protection in the state. A lot of people just say, yeah, fine, it's a kind of noblesse oblige, you know, you give me protection, you have some privileges, and because you have such a heavy responsibility. Now this is the same idea about the axiom about masculine protectionism. It's become a false axiom. Okay, what I've actually told you about is a false axiom. Okay, the masculine protectionism never worked, it has never been followed, and it has broken down, and it's dysfunctional. And this is where I think we should try to address the system. If we want to have a dialogue, we should start with that. Yeah? And let's not talk about equality yet, and see what they have to say about this. Yeah. Thank you very much.